Okay, Afi, so we got some of our people that are putting in some really, really insightful questions here in our chat. And one of the questions from Danny from YouTube is, and this could be a very real reality, a really long trial, lots of witnesses. Who knows what can come up in a trial, like maybe somebody will get stabbed in the middle of the case. So the question here from Danny is, what happens if they run out of alternates?
Oh my goodness. So that's a question. That's a very good question, and it's something that the judge takes into account in the very beginning. I believe that with a jury of this nature, they have a significant number of alternates. And correct me if I'm wrong. When you have a 12-member jury, sometimes you'd have 2 alternates, sometimes you can have 4. It just depends. But I think that it's going to be a rough situation if they do run out of alternates. I don't know that the judge would have to stage a mistrial, and I think that that's something that he does not want to do in a situation like this, because it's gone on for a while, and you've had these defendants who are in custody and haven't been given a bond. So I think that that would be a nightmare situation. Great question.
Yeah, I run out of alternates. As far as I'm concerned, that's the end of the day. That's a mistrial, and that's a big loss for prosecutors. Like you said, I don't know. Sometimes you get judges that make it really tight. You try to tell them we need a lot more, and they're like, no, 14's enough, 16's enough, and then things happen, and you're down to one last one, or no alternates left over, and it could really be a nail biter. I know Gene Rossi knows that, but I also know Gene Rossi knows this. David Gaffney from YouTube says he still wants to know if the state is successful, Gene, will the defendants in YSL as a record label lose all assets, even legitimate assets such as record sales? That's a good question.
Well, if they can show that the proceeds of their enterprise were used to fund the record label, then you could trace those assets. It's just classic money laundering, and you're going after substitute assets or assets that are traceable. So yes, it's possible that those proceeds of the record label could be forfeited. Okay,
excellent. Yeah. And that would be a whole procedure, right? Afterwards, I assume a court would have to go through all of that to make that kind of connection, or does a jury decide that? I assume it's a judge.
At the federal level, you can have the jury decide whether certain assets are forfeitable, or a defendant generally waives it and allows a judge to do the forfeiture rulings at the sentencing.
Very interesting. Okay, great. Afi, let me go to Teresa Trice from YouTube. And she asks, I assume it's a she, given the majority of witnesses who have testified to charges dropped for this case that are apparently brought back. Let me see if I get it right. Witnesses have testified to charges dropped and for this case apparently brought back. How does that affect the trial? I think what's being asked there is that a majority of the witnesses have testified and had charges dropped or received plea agreements and may be coming back to testify. How does that affect the trial? I think that's the import of the question.
I got it. Fantastic question. And this goes back to the importance of opening statements. I think the second defense attorney that got up, he knows that we're going to have a lot of witnesses who've taken plea deals. And he said something, he talked about Fulton County, and he talked about all of the prosecutors' witnesses. He said, when they get up there, these are their men in blue. And he really emphasized how horrible a reputation that Fulton County jails are, and how you just do not want to be in Fulton County blue. And if you're faced with that prospect of being in Fulton County, you'll say whatever you need to do so you don't have to be in that Fulton County blue. So I think that that was really good that the defense counsel said that, because that's the nugget that I've held on to even after all this time.
Yeah, I want to answer that, and I'm going to flip this one to Gene because I think it's a really good question. It really depends. I think somebody had mentioned this before, how your witness testifies, how credible they seem to be. Of course, the defense is going to attack them, that they have a motive, an expectation of benefit, they call it, in order to get a favorable resolution from the government. But many times the feds included, Gene could talk about that, use those very kind of witnesses, especially in a RICO case, in order to testify. By definition, they're involved in bad things. Gene, what do you think about using those witnesses, flipping them and giving them light plea agreements? Do you think that they're valuable? Does it depend on a case-by-case basis? Thoughts?
It's a case-by-case basis. and I'll give you a couple examples. I had one drug trial, organized crime and drug trial, where we had two witnesses that pleaded guilty to perjury before a grand jury. In our trial jury, the jury loved them. They admitted they lied. They admitted why they lied, but their demeanor and the way they explained things and that their testimony was corroborated, the jury believed them and they were found guilty. Case I just had, we had witnesses that were given immunity that had admitted they lied. I tried to attack them, but at the end of the day, it just depends on a case basis, whether a jury will believe what they say and will they say something that is corroborated by uncontested evidence, like a document.
And Alexa Rose from YouTube, I think that pretty much answers your question. It seemed very similar about if they plead guilty and testify, how does that affect the state's case? So I think we knocked that question off as well. Afi, let me ask you, inquiring mind from YouTube wants to know, how does a judge get selected for a high-profile case? With all due respect, this judge seems overwhelmed.
It's different in every jurisdiction, but usually it's sort of, I'll just give you an example for, when I first got out of law school, when I was a public defender, it would depend on the day that it's kind of like a lottery. If it was a murder, for example, it would depend on who was on duty, the duty judge when the murder was committed. It really depends by jurisdiction. Sometimes jurisdictions are divided into judges who handle just arraignments, judges who handle felonies, judges who handle misdemeanors. So it's usually a lottery system. You don't get to select a judge because you always want to have just an appearance of a neutral and detached magistrate, which is the judge. So from my experience in different jurisdictions, it's kind of like a lottery system. And it just depends on, the luck of the draw, if you will.
All right, guys, I'm going to ask each of you this question because it's deep and maybe complex, and we may have different points of view. Lisa Simpson Rules from YouTube asks, what are the most probable causes for a future appeal if the jury convicts them? There have been a number of fishy things so far, in my opinion. Afi.
I think, it was mentioned earlier, I hate to use the word, I'll just say it, the sloppiness of the prosecution. I think they slipped a number of things before the jury that they really shouldn't have. And I think the judge has been, the judge is getting a little bit more stern with them. But, just from day one, when we started with the opening and you put someone's criminal charges up there and, that was a complete violation. I think Steele got up there and did what he was supposed to do, call for a mistrial right away. But I think, and as the trial goes on, they're going to, if they don't tighten up and they continue to be sloppy, they're going to expose themselves for reasons for appeal. And, they just started out of the gate with day one with that.
Yeah, and things can become cumulative too. Sometimes an appellate court will say, after all of these things get there. But Afi, I want to add, one thing. Let's be clear, in my opinion. You guys tell me if I'm right or wrong about this. I think that's the biggest, most egregious error that's been done because it violated the cardinal rule of burden shifting and commenting on a defendant's right to remain silent. In my mind, that mistrial motion, though, made by the defense, which is something that they had to make. How much, Afi, do you believe they were crossing their fingers saying, Judge, please don't grant it. Please don't grant my mistrial motion. I want to preserve it for appeal, but I want a shot at trying to win at this trial.
That's how I would have felt. Please don't grant it. I have to do this. I have to preserve this. But, I think we're going to do pretty well at this trial, because the problem that the prosecution has in this trial is, of course, losing their jurors. They're piecemealing so many things together. And it seems like the issues that they're focusing on seem so minute. So I think that, the defense definitely wanted to continue, but they had to do, what was in the best interest of their client, which is preserving this matter for appeal.
Gene, I think you're going to agree with that comment that Afi had as well, but please opine on that. And what about the RICO law, the stretching of the RICO law, the use of the lyrics, the introduction now of all this other evidence that typically would not be admissible if it wasn't for a RICO charge? What are your thoughts about the success on appeal?
I want to address the appeal issue. My experience is a lot of appeals are result in reverses because of bad jury instruction. The elements of the crime were not properly presented to the jury. I've had a couple of reversals where, as a prosecutor, I got a little greedy and the jury instructions were a little too aggressive. So that's one area. Second area is what we've just been talking about, the burden shifting. And since you got some educated listeners here, in 1963, Griffin versus California, Supreme Court said a prosecutor cannot comment on the failure of a defendant to take the stand. Before that, they could, but then they said they couldn't. And then Doyle versus Ohio is when a defendant invokes the Fifth Amendment during an interrogation, you can't comment on that. So what happened in that opening is she kind of touched on both of those landmines, and I agree, I don't want my motion for a new trial granted. I want it denied because I want two bites of the apple, one on the opening statement and two on the hung jury or acquittal. And the last thing is evidence. Allowing evidence in or excluding it are also bases for reversals. Mm-hmm. I go back to Bianchi. Other crimes evidence. Prosecutors get very greedy on putting in other crimes evidence. And Bianchi has a case where they complimented him because he held back a little bit and didn't get greedy.
Yeah, definitely. And I think that that's where I bring in the RICO piece to it, because RICO allows so much more evidence to get in there that if it's a weak case and they get greedy on that evidence, you may be right into that situation that you're talking about. A lot of landmines for sure, guys. Okay, awesome commentary.